Your dictation will start within 5 seconds. In the light of documentary evidence available on record, learned counsel for the appellant invited attention of this court to the specific finding recorded by the tribunal where it is said that the appellant, having failed to produce any record beyond 15th April 2003, thus suppressed the relevant evidence, hence the liability. It was argued that the tribunal, by making such an observation, clearly fell into an error once the relevant record of vehicle movement register was made available up to 31/5/2003. The submission put forth was carefully analyzed in the light of material placed on record. It is seen that photocopy of the agreement between the appellant and the owner, i.e., respondent number 2, placed on record indicates that the offending vehicle had come in the operation of appellant under an agreement. Insofar as the operation of vehicle as on 21/4/2003 is concerned, there is no specific denial in the written statement by making a mention to the agreement and date of its validity. If any agreement between the appellant and owner of the offending vehicle had overruns its validity period as on the date of accident, there was no reason as to why such fact would not find mention in para 24 of the written statement. The denial of liability in paragraphs 37 and 38 also does not make a mention of the agreement which existed between appellant and owner of the vehicle. This clearly goes to indicate that the appellant had not set up a case on the strength of agreement of which a photocopy was filed and the invalidity whereof ought to have been proved on the strength of evidence. The agreement placed on record, however, gives a sufficient indication for this court to draw an adverse inference due to the reason that the agreement does not bear date of its commencement in the opening para. It is further gathered that the addition of period of validity in the relevant paragraph is handwritten, whereas rest of the paragraphs drawing the agreement valid for a period of 11 months, extendable for a further period of 3 months, would make the sense complete. The addition in handwriting restricting the operation of agreement is suspicious. The date mentioned at the foot of the agreement is not clear as to its validity, which reflects nothing but an evasive attempt on the part of appellant. The agreement having been filed by the appellant along with an affidavit shows that there was a contract between the appellant and the owner whereunder possession of the vehicle vested in the appellant as on the date of accident. The appellant had also placed on record a photocopy of the vehicle movement register which was handwritten, but photocopy of the document which contains a resembling number of the vehicle involved was not found admissible and was also not proved by the appellant. Objection as regards the possession of the vehicle under a contract in the facts and circumstances of the case cannot be disbelieved even if the finding recorded by the tribunal is found to be erroneous. This court, while exercising the appellate jurisdiction under Section 173 of Motor Vehicles Act, is competent to record a finding of fact having regard to the material available on record once possession of the offending vehicle is found to be vested in the appellant on the date of accident and the view taken is supported by the apex court decision rendered in the case of Uttar Pradesh State Road Transport Corporation versus Kusum and others 2010 8 SCC 238. The question that crops up is as to the extent of liability that can be fixed